What I'm trying to get at, Mr. Assistant Attorney General, is that despite your efforts here today, despite the evidence that the Panthers, this particular new Black Panther Party's attempts to spark a 300 precinct revolt failed miserably in the hands of two overly aggressive and misguided individuals, that some, and despite the fact that there have been no other allegations against the department, that they have failed to prosecute 11B violations anywhere else in this country. Nevertheless, the likelihood is very high, and I just want to be very frank with you, that this commission, I will not join the vote, by the way, as you can probably tell, may come out with a report stating that that your department has somehow failed in enforcing the civil rights laws of this country with regard to voter intimidation. And I'd like to know, for the record, what would your response be to that kind of report coming forward based on this single incident at this single precinct, this single charging and prosecutorial decision that was made by your department? How would you feel if the U.S. Commission on Civil Rights came out with a report somehow condemning the entire Justice Department for its failure to enforce 11B?
Well, I'm simply hopeful that the Commission's reports, and I think your national annual reports are important vehicles.
I apologize, Mr. Perez, but it was
complete.
Thank you. It was a very long question.
No problem.
You can answer it when my turn comes up next.
Commissioner Graziano.
Oh, you're yielding?
No, you have 5 minutes.
Okay. We received a letter last night from Mr. Hunt responsive to the chairman's letter to Attorney General Holder, raising several questions. And one of them, you know, since I was a defender of the President's executive privilege, no one believes more strongly that when the President and Attorney General invoke it, that it needs to be respected. It doesn't mean that it's absolute, of course, but as you know, as the Chairman's letter to Holder indicated, the Supreme Court has been very clear. The case at United States versus Reynolds, executive privilege, quote, is not to be lightly invoked. There must be a formal claim of privilege lodged by the head of the department, which has control over the matter after actual personal consideration by that officer. That means personal consideration by the department head or attorney general. Now, in that letter, the department, without any authority, and I know the authorities in this area, without any authority, because none exist, said that the department's non-executive privilege confidentiality interests override the statutory command Congress has instructed you to comply fully with our request. And then the final sentence of that letter is that since you think you're right, the department, since the department thinks it's right that our statute, our subpoenas are inferior to whatever interests the department has, therefore, it's inappropriate to appoint the special counsel that we've requested to allow a judge to determine this. In what other situations is the entity, in this case the department, that has the conflict of interest get to decide how that conflict is resolved?
Sir, Commissioner, one of the things that I think has to be clear in the record, because I think your question leaves it unclear, is that we have not invoked executive privilege.
No,
and it is,
I'm glad
and your question, I'm sure you didn't intend to, but your question, a reasonable person could interpret as having implied that we have invoked executive privilege.
That's part of the letter and part of what's curious, because in the absence of the President, all the President or Attorney General need to say is, I hereby invoke executive privilege after careful personal review. Again, the Supreme Court says it's not to be lightly invoked. And then we might have a few questions about whether you're willing to waive it for this, that, or the other. But in the absence of the Attorney General or the principal or the President invoking executive privilege to deny us material, you have asserted that you're confident, that's not the exact word, but you think your other interests, confidentiality interests, override our statute, override our subpoena. Okay, we have a dispute about that, a legal dispute about that. We have asked you, since you are the department that's supposed to enforce our subpoenas in court, we have pointed out this very embarrassing conflict of interest the department has. And we have asked for a special counsel who would help us go to court to get a judge to determine who's right. Who's right? Do our statutes that require you to cooperate fully override your other non-executive privilege? Or not? What other situations does the department with the conflict or the entity with the conflict get to decide the outcome of that conflict?
The confidentiality interests, again, this back and forth that we have had in terms of providing the 4,000 pages of documents and including FBI statements, including other materials, is exactly the back and forth that we do when we have the House Judiciary Committee or other committees that ask us for information and ask us to produce the frontline attorneys.
There's a difference. They can hold you in contempt and they can go to court. Our statute says that you are to enforce our subpoenas. The department is to enforce our subpoenas. That's the conflict. And so we have asked for a special counsel. The question is, if you're so sure about your legal position, why not allow a judge to decide that?
The congressional statutes do not...
Long question, same deal. Commissioner Yockey.
I believe I had 4 minutes reserved from...
That is correct.
As well as my 5 minutes?
That is correct.
Thank you. I'm going to use it all right now, perhaps. Just to go back to the question that I raised before, again, aside from the fact that we seem to be devolving into whitewater territory all over again, what if the commission were to based on its re-prosecution of the evidence in the Black Panther case, come to a conclusion that the Department of Justice has been failing in its efforts to deal with voter intimidation in this country, how would you respond?
Well, we have an aggressive program of of law enforcement to address issues of voter intimidation. I described the case in New York that we just prosecuted. I've described both the guidance that we are in the process of putting out to address a wide range of voter access and purging and other issues. And we are working very vigilantly in those areas. And you have a job to do. You're going to put out a report. We will look forward to receiving that report. And we have there are times when we disagree. We have a different point of view. There's remarkable ideological diversity around this table today. And that is not a news item. That is a fact. And that's what makes our country great, is we have ideological diversity around a host of issues. So I know that you have your job to do, and we have our job to do. Our job as law enforcement to apply the facts to the law to make sure that we are fully and effectively enforcing those laws to the best of our ability, and that's what we'll continue to do.
But if someone were to say to you, the U.S. Commission on Civil Rights is accusing the Department of dropping the ball on voter intimidation, I take it you would probably disagree strongly with that.
I would disagree.
It's nicely diplomatically put. I might put it a little bit different, even more stronger than that. I have a very quick question. There's been a lot of talk. You know what? I'm going to reserve the balance of my time.